numbers on mute then, and then figure it out like that. Who's the participant that you are looking for? You only
Yes.
have like 7 of them.
Right. I have muted everyone in my controls. I am now switching to out of the host screen, and I'm back on the participant screen. Did someone say I have participants on the second screen? One moment. Okay, and which phone number was Ms. Peterson?
Yes, ma'am. She says she's at 772-913-0711.
Thank you, Mr. Appel. We're referring to Ms. Paris.
I'm sorry.
Okay, does anyone see that phone number on the second screen?
That number there. No.
I don't see it either.
And this Ms. Peterson's number, 850-212-8665.
Okay.
That one I see.
Yes, I see that one. Well, she should be on now. Ms. Peterson, can you hear us talking about you?
Your Honor, I heard that she can hear us, but she can't speak for whatever reason. But
Ms. Peterson, can you hear me? All right, one moment. Well, I've just muted her, but I don't want her muted.
Yeah, but she wasn't muted.
Yeah, she's not muted at my end.
Yeah,
So she has an issue at her end.
exactly.
Sometimes you have to select join with audio.
Okay, she needs to call back in, please. If she can hear me, she needs to call back in and join with audio because the issue's at her end. All right, and with Ms. Paris, did someone say she is on my screen somewhere?
She said that she had called in, Your Honor, but I'm asking her to call back in.
Okay, do you not see that Ms. Peterson has logged out and logged back in? Can someone communicate that to her?
yes, Your Honor.
Thank you.
Judge Croom, I'm the court reporter. Is it okay if I unmute myself in case I need to interject?
Yes, ma'am. Thank you very much. All right, any word on Ms. Paris or Ms. Peterson? I see Ms. Peterson still on and she is not muted at my end.
Your Honor, I did communicate that to her, but pursuant to our plan for the hearing, I would be doing this speaking on the motion, and Ms. Peterson is joining in, and only if the court had questions for her. But she's logging back in as I understand it.
Your Honor, Ms. Paris just texted me. She said she'd be on at 772-913-0711.
I couldn't hear you.
711.
Did you see? One moment. Ms. Paris, can you hear me?
Yes, Your Honor.
All right, excellent. We are just trying to rectify one other person, which is a Miss Peterson. One moment.
Unmuted.
Miss Peterson, can you hear me?
Yeah, I can hear you and see you, Your Honor.
All right, you are having a very strong echo. I need you to put us on mute until you're speaking because you have an echo system. Is that okay?
Yes, ma'am.
You are muted.
Okay. Ms. Peterson? Okay, did that seem to rectify it? No.
I think I fixed it.
No, Marilyn?
This is Marilyn, if I may. I believe that the problem that she's having is that she's connected in two different devices at the same time, probably a phone and the cell phone. So she needs to leave the audio on one of the devices.
Can someone communicate that to her, please? I would like to move forward with the hearing if she can hang up one of her devices.
Yes, Your Honor. So, Mr. Barfield.
All right, Ms. Peterson, are you able to hear us?
Yes, ma'am.
Mute part of this hearing. I should have Mr. Barquette and Mr. Vatunik appearing by the same number. Mr. Rappel, Mr. Kessler, Ms. Paris, Mr. Barfield, and Ms. Peterson. So if you can announce your appearances in that listing for the court reporter, then we'll have a complete record, please.
Good morning, Your Honor. Jonathan Barquette here on behalf of the plaintiffs.
Morning, Your Honor. Craig Rappel on behalf of the defendant, Damian Gillens.
Good morning, Judge Michael Kessler here on behalf of the defendant, Charles Motti.
Good morning, Your Honor. Pamela Perez, Sebastian City Councilwoman attending.
Good morning, Your Honor. Michael Barfield on behalf of intervener, myself, pro se.
And good morning, Your Honor. Barbara Peterson on behalf of myself, pro se.
All right, Madam Court Reporter, do you have all the appearances that you need?
I do, thank you.
All right, you're welcome. We're going to go ahead and start the hearing. I do ask that everyone who is speaking, please announce your name before you speak. It makes for a better record for the court reporter to be able to keep an accurate record. So for the first motion I understood was scheduled today was the motion to dismiss that I've already denied. Is there something further on that motion?
Craig Rappel, Your Honor. Yes, Your Honor. The motion to dismiss at the time, as we told the court, was 15 pages in length. With respect to the emergency hearing, we were obviously attacking it on subject matter jurisdiction for the court to hear the temporary relief. But we didn't have time to go through the rest of the arguments in the motion to dismiss. We were raised under 1.140 Florida Rules of Civil Procedure, including the fact that there was failure to state a cause of action, failure to join in parties. We also had a motion to strike the references to the attorney's fees at the time. Succinctly, our position, Your Honor, is,
Your Honor, I'm sorry to jump in here. I know this is hard over the technology, but yesterday, and I apologize to everyone for this being a little late, but we got the transcript of the hearing from yesterday, and you clearly stated that the motion to dismiss is denied. It was one sentence. It wasn't part of the motion to dismiss. So if Mr. Rappel wants to have this heard again, it's our position that he needs to file a motion for rehearing or something along those lines, because we are taking this that this has been denied.
Right, and so that's my intent from the last hearing. I had, for the record, already reviewed all of the pending motions at that time, including the motion to dismiss. I heard argument on the motion to dismiss. I ruled on the motion to dismiss. I don't intend to have a re-argument of the motion to dismiss. Everyone made a very long and complete record on that, including a request to be able to file cert. And so unless there's something new that wasn't already written in the motion to dismiss, my order extended to the motion to dismiss in its entirety. And again, y'all made a clear record on your ability to appeal me. All right, is there anything further I need to rule on the motion to dismiss?
no, Your Honor.
All right, so moving on, the next one I have, well, let me put that one to bed. I need a proposed order on the motion to dismiss. Mr. Barquette, can you please prepare that order, circulate it to opposing counsel? Please always be sure to put in the order that there was a court reporter present at both hearings That way the appellate court always has a clear understanding of what happened at the trial court level.
Yes, Your Honor.
All right, the next motion I have down is a motion to consolidate. Is that the next appropriate motion to hear?
We believe it's Craig Rappel again. We believe it is, Your Honor.
Your Honor, this is Mr. Barfield. I would suggest that the motion to intervene should be heard next, because if the court grants our request for full party status as opposed to subordinate status, we would be entitled to be heard on the motion to consolidate.
All right, I believe I can rule on the motion to consolidate as a matter of law. I've read all of the papers all weekend, and so I'm prepared to rule on the motion to consolidate based on the papers. I believe I can do that without an intervener status for a consolidation matter. Can y'all address that from a legal standpoint?
This is Mr. Barfield. As it relates to the motion to consolidate, I think that's in the court's discretion. And so I don't have anything further to offer as it relates to that matter.
All right. Yes, sir. Thank you. All right. I will hear the motion to consolidate, and so that we don't repeat what's already filed in the papers. I have studied y'all's papers all weekend, and so I will hear a condensed version of your motion and the response. You don't have to repeat what is in your written papers. However, I will allow you to make a record.
Thank you, Your Honor. Craig Rappel speaking on behalf of Mr. Gilliams, who is the proponent for this motion to consolidate. As the court knows, we filed a separate suit, 275. Theoretically, we could this is a counterclaim, but it was brought for issues, as the court knows from our arguments on jurisdictional issues of caution, and it's a 275. The facts are all consolidated in the sense it's all arising out of the same series of events and basically involves the same individuals with respect to the various sundry roles within the city government itself, and as well as the issue with the Sunshine Law.
Response.
Your Honor, Jonathan Barquette, we would disagree. We don't think that they arise out of the same events at all. In fact, the individuals being sued in Mr. Gilliam's complaint aren't even the same individuals who were present at that meeting. We think it's clear that if the plaintiffs and if Mr. Rappel's clients want to put their grievances before the court, it needs to be done so in a separate matter, because that is a review of how the city is acting versus one single meeting, which was the subject of our complaint.
All right. Any reply?
Again, Your Honor, no, except for the fact that their argument is that our clients illegally met violation of the Sunshine Law. And of course, when the court read the counterclaim, can see the factual basis leading up to it and the declaratory relief that they were seeking.
All right, one moment. All right, for the record, I have reviewed all the motions and responses with regard to the motion to consolidate. I have heard argument of counsel regarding same. The motion to consolidate is denied. The court adopts the plaintiff's position herein. Who's preparing this order, please?
Prepare the order, Your Honor.
Who was that?
I'm happy to prepare it, Your Honor.
All right. And again, if you will always put that a court reporter was present, that way an appellate court always has a clear understanding of what happened at the trial court level.
Yes, Your Honor.
All right. I believe the next motion I have, well, I have two, I see. One is a motion to intervene and one is a motion to postpone mediation. With regard to the motion to postpone mediation, is that issue moot? The mediation was supposed to have occurred last week.
Your Honor, I think that the fact that it was postponed is moot. I think the clarification that the parties are requesting from the court is the only thing left to be determined.
Judge Michael Kessler on behalf of Mr. Motti. I think technically the mediation wasn't postponed, it was convened, and then the mediator adjourned it pending some guidance from this court on to what extent it would have to be open to everybody else. We would like that resolved as soon as you're able, because we want to get back to work on this.
All right,
All the parties
understood.
agreed to mediate.
All right, so with that statement, then it sounds like I should hear the motion to intervene next. Is that correct?
Yes, Your Honor.
All right, Mr. Barfield, I'll hear your motion.
Thank you, Your Honor, and thank you for specially setting this hearing on short notice. Based on the submission of the parties late Friday, I believe the only dispute left for the court to resolve is the scope of the proposed intervention. Rule 1.230 provides that ordinarily intervention is subordinate unless the court, in its discretion, determines otherwise. The defendants contend that intervention should be subordinate. We respectfully disagree for the reasons set forth in the intervener's memorandum of law. But there is one additional reason that warrants full intervention that is particularly compelling based on the circumstances of this case. And that is that the public is the real party in interest here, Judge. And that interest can only be protected by the court exercising its discretion to allow full party intervention. The issue to be determined in this case is whether the acts of the defendants violated the Sunshine Law. I want to emphasize that the purpose of the Sunshine Law is for the benefit of the public. Since the enactment of the Sunshine Law in 1967, the Florida Supreme Court has clearly stated that it was enacted for the benefit of the public and must be broadly construed to effectuate that purpose. Transparency instills confidence in government, and it is an essential component of the consent that citizens give to be governed. Judge, the city of Sebastian is in turmoil. At best, citizens are bewildered by recent events, and at a time when public confidence is shaken by a pandemic, we have a situation where, accepting the allegations of the complaint as true as we must at this stage of the proceedings, a current majority of the city council kept the public in the dark and literally locked City Hall while conducting city business until the police showed up, when they abruptly adjourned the meeting. You will note that the parties to this lawsuit are not members of the public. They are the elected and appointed officials of city government. The public is not represented in these proceedings. As we learned last week, when the scheduled mediation was postponed, the public would be shut out of any mediation. And if the public is omitted from these proceedings, Your Honor, the only thing taxpayers in the city of Sebastian are certain to get is less confidence in their city government. And with due respect, our transparency laws do not belong to the mayor, the members of the city council, or the appointed officials. The Sunshine Law is a right that belongs to the public, and unless the court grants full intervention, the public will be shut out of the right to vindicate the Sunshine Law. There certainly isn't much confidence among the citizenry that the current parties will keep the public's interest ahead of their individual interests. And relegating the real party in interest in this case, public, to subordinate status is simply inconsistent with construing the Sunshine Law broadly to effectuate its public purpose. The public has already been shut out of City Hall, and the court should exercise its discretion to ensure that the public is not left out of these important proceedings. Unless the court has any questions, I will rely on the memorandum for the remainder.
Yes, sir, I have read all memorandum. I do have a question for the plaintiff and the defendant. My understanding from our last hearing last week was that y'all agreed that the actions were void. And so I'm unclear at this point, since that agreement is in place, what exactly, subject matter wise, y'all would be mediating.
Your Honor, for this case, there's nothing further to mediate other than potentially the issue of, this is Jonathan Barquette, I apologize. The issue of potentially fees or the defendants, actually in this case, that's probably it. There's not much left to, in the 6-9 matter, to mediate. I think last week, in order to come to some sort of agreement, we were looking beyond the scope of this case, but at this point, I'm not sure there is much left.
Your Honor, this is Craig Rappel speaking. I agree with most of what Mr. Barquette has to say, but obviously the order also included 275 issues and 275, and that is, when is the council going to meet again in special session, or whether even the future hearings will be canceled until the governor lifts the requirements. And in addition, the fact of the matter is, if anything else, it would be if there is going to ever be another renewal of sunshine law violations.
All right. So again, because I denied the motion to consolidate, what is the issue that is left to mediate in the case that's currently before me?
Nothing in this case, Your Honor.
Right.
Just the fees. Nothing in the 6-9 case.
Mr. Rappel?
Well, your order had both cases, but other than that, if we're just looking at this case, then the answer is yes, there's nothing left else to mediate with respect to this issue.
All right. So is mediation moot then in this case?
In this case, Your Honor, it could be moot, yes.
Mr. Rappel?
Well, I would think so, yes.
All right. And so if the issue of mediation is moot, then does that in effect mean the motion to postpone mediation is also moot and the motion to intervene in this case is also moot?
Craig Rappel, on behalf of Mr. Gilliams, the answer would be yes, Your Honor.
On behalf of Mr. Motti, the answer is yes. Michael Kessler speaking.
Jonathan Barquette, yes for the plaintiffs.
Pamela Paris, yes, Your Honor.
Your Honor, as it relates to the mediation postponement, yes, but not as to intervention.
What would the intervener's interest be in the case if the underlying issue has already been agreed to be that the actions were void and against the law, number one, and number two, there is no mediation? What would the intervener be seeking to intervene in?
Your Honor, we believe that the Sunshine Law allows actions to be cured, and the defendants in this case can cure those violations, and at the point in time that they cure them, there may be issues relating to the sufficiency of the cure. And I understand that the court has issued a temporary injunction or an agreed order declaring the acts void, but it was my understanding that was for the purposes of maintaining the status quo. The only other matter would be a declaration in this case that the Sunshine Law was violated.
All right. Well, the agreement from last week had no qualifications. All attorneys, per the record, show that they agreed the actions were void. Am I wrong on that? Mr. Rappel and Mr. Barquette and Mr. Kessler?
Jonathan Barquette, Your Honor. We were operating under the assumption that we would still be going through and getting the declaratory judgment or moving down that path. We were certainly willing to discuss, certain things at that time in mediation, but we were sort of the same mind that the injunctive relief was to preserve the status quo and that the declaration would still be forthcoming. I may have misspoke earlier as far as the whole thing being moot, but I was thinking along the lines of the mediation and some of that, but I'll let Mr. Rappel weigh in.
Craig Rappel on behalf of Mr. Gilliams. Yes, Your Honor, that was actually my understanding, that we would still have the court eventually handle the declaratory relief action.
Michael Kessler on behalf of Mr. Motti, that was my understanding as well.
All right. And Ms. Paris, is that your understanding as well?
Yes, Your Honor.
All right. With that record being made, the motion to intervene is granted.
Thank you, Your Honor. I will prepare an order and circulate it to council.
Yes, sir. Thank you. And again, I know you've heard this several times now. If you will please put that there is a court transcript available. That way an appellate court always has a complete understanding of what happened at the trial court.
Thank you. And just to clarify, Your Honor, is that granted with full party status?
It is.
Thank you.
You're welcome. One moment. All right, so that leads us to the motion to postpone mediation, which for purposes of today's hearing is not a real motion to postpone mediation, but which does address the mediation status. Is that correct?
Yes.
Okay, go ahead with what issue needs to be resolved with the mediation.
Your Honor, the purpose of this is Jonathan Barquette. The purpose of the motion to postpone and any future mediation in this matter is simply clarification. We obviously received lots of letters, calls from very qualified individuals who were concerned that if we were to mediate as planned and on schedule, we might run afoul of the sunshine laws. And so we wanted to make sure, one, that we complied with any and all requirements that the public be there, and number two, that we protected our clients, all of our clients' confidentiality. After speaking with the mediator, who in our case is very knowledgeable and experienced, he agreed as well. So we just wanted to make sure that if there were some notice requirements for the public and if they had access to that information on time, that was important. And to make sure that we had some direction from the court so we weren't unwinding any progress that we all made later. You know, it could be technically a little difficult, especially over Zoom, for the mediator to facilitate, for example, me speaking with my clients privately, but then coming back to speak in a manner where the public was entitled. And also anything we agree to, depending on how the case law is interpreted, we might not be able to agree to anything until it's ratified by the public in a proper meeting. So we need to make sure we know what we have the authority to do and not to do behind closed doors and in the open. So we're requesting some guidance from the court so we could all be on the same page and not waste our time fighting over the technicalities.
All right. So essentially you're looking for an advisory opinion on issues to be mediated, which appear at this point to only be attorney's fees. Is that correct?
At this point, in this case, Your Honor, yes.
I would disagree. Michael Kessler on behalf of Mr. Motti. As we've heard earlier, we're also looking for a remedy here, and the remedy that Mr. Motti is seeking is for the city council to get back on track, have a meeting, and get back to doing the city's business. And that's something that's going to have to be part and parcel to any conversation at mediation.
But I've not consolidated the cases. So would your argument be better crafted in the case that is not consolidated?
I don't think so, Judge. I think the city council still has to get on with its business, and I think that's going to be part and parcel of the conversation at any mediation on case 269.
So I need you to vet that out a little bit for me, because judicial intervention on a city council setting of hearings would seem to not be affiliated with the current case I'm hearing. Can you explain it a different way?
Well, Judge, it seems to me that part and parcel of case 269, factually and legally, is whether under the current status quo that the mayor and the city manager, two of the three plaintiffs, and the city attorney can indefinitely stop the city council from meeting. That's really what's at the heart of this lawsuit.
Your Honor, Jonathan Barquette, we would definitely disagree with that. What's at the heart of this lawsuit is whether or not the meeting of the three council members was legal and a violation of the law. It has nothing to do with the validity of the cancellations, the plan moving forward. None of that was the subject of this suit. This suit is merely, did that single meeting violate the law?
Judge, I respectfully disagree with Mr. Barquette. Again, Michael Kessler. The legality of the meeting being canceled, the procedure of the meeting being canceled, and whether they're going to forestall any future meetings is the whole issue of this case as it pertains to the events of April 22nd. It's part and parcel of the same thing.
Your Honor, even Jonathan Barquette, even if all of those things alleged in the other complaint, which is what Mr. Kessler is referencing, at least factually, were true, it doesn't have any bearing on the legality of the single meeting. Even if all those things occurred, even if the validity is questioned, even if there is some argument that things need to change moving forward, it doesn't validate a secret meeting. That's not the issue in this case.
All right, I need to hear from Mr. Rappel and Mr. Barfield, please.
Yes, Craig Rappel on behalf of Mr. Gilliams. Well, Your Honor, obviously, as we sit here today, with the motion to dismiss, there still needs to be an answer filed by the defendants, which is just and proper, and they could also bring counterclaims as well. And so I have to disagree with Mr. Barquette because they could theoretically make arguments that there was no cancellation of the meeting. They could do that.
Your Honor, this is Mr. Barfield. I think it's problematic for the court to grant the relief being sought here, which is tantamount to an advisory opinion. And I just think that's rife with a lot of problems at this point and at this juncture in the proceedings, without an answer being filed by the defendants as the potential counterclaims that Mr. Rappel mentioned. So I think that the court giving advice on how mediation should be conducted in compliance with the Sunshine Law, and whether meetings should be scheduled and how they should be scheduled is beyond the purview at the court at this point.
That was what my original question inquired of, if it would be an advisory opinion on what essentially would be attorney's fees issues for this particular case. Mr. Barquette?
Your Honor, to be honest with you, you broke up just a little bit there. I'm getting a little bit of interference. If you could repeat that.
Yes, Mr. Barfield essentially repeated what my inquiry was when I started this motion, which was, would anything I said today simply be an advisory opinion on how to conduct a mediation on what is essentially attorney's fees for this particular case?
It may be, Your Honor. It may be that. To be honest, this is new ground for all of us, I think, and I am of the mind, as you know, that the only thing before the court is that meeting. So I would say everything else is beyond the purview.
Mr. Kessler?
Judge, I disagreed, but I'm not going to make the same arguments again. I think you understand my position.
Yes, sir. It was well articulated. Thank you. Mr. Rappel?
Nothing else further to add, Your Honor.
All right. Yes, sir. I agree with Mr. Barfield that it would be an advisory opinion for me to rule on the what's currently phrased as a motion to postpone mediation. For those reasons, that issue is going to be deemed by this court as unripe. Everyone's made a complete and full record on that motion as well. So with that being said, who's preparing that order?
I will volunteer, Mr. Barfield, Your Honor.
Yes, sir. Again, with the same information about a court reporter being present, please. Are there any other pending motions for today?
I don't believe so, Your Honor.
No.
Mr. Kessler?
I have no motions pending, Judge.
Mr. Rappel?
I believe we've covered the motions that were pending that I believed were on the calendar.
All right, Ms. Perez?
No, Your Honor, I'm satisfied. Thank you.
All right, thank you. So for the case, for these issues, probably entering into the judicial forum was not anticipated by any of your voters or members of the beautiful Sebastian community. I would strongly encourage moving past these issues, working together with your attorneys so that you can go back to wisely governing the citizens who voted for y'all. We are in a pandemic. I anticipate that everybody should perhaps take a pause and rethink their positions and come to the table with a clear head so that you guys can go back to governing and not be in the judicial system. All right, when might I receive those proposed orders?
Your Honor, I can circulate them by the end of the day, and if you let us know a date certain by which council has any objections as to form and content, that would give some guidance.
End of day is fine for the ones I was preparing, Your Honor.
All right, motions to be circulated as stated by council. You all have a day to review those and either agree or disagree. I anticipate that there would be no disagreement because the issues are frankly pretty straightforward and clear. There's also a court reporter present, and y'all are all very reasonable attorneys. So I anticipate not to have any issues with getting agreed orders on what happened here today, even though you may not agree with how I ruled. Is there anything else we need to cover today?
Nothing further from Mr. Motti.
Nothing further from Mr. Gilliams, and we'll see you on Friday, Your Honor.
Nothing further, Your Honor. Thank you.
Your Honor, nothing further from me, but I want to make the record clear that I'm not an attorney and I'm proceeding pro se in this matter.
Nothing further from the plaintiffs, Your Honor.
All right, and do I understand that the next hearing is Friday?
Mr. Gilliams, yes, Your Honor, we filed a motion for injunctive relief to be heard on Friday with respect to the city council not meeting.
Right, is there any briefing that needs to have deadlines set for that motion, or is it straightforward and no one needs to submit briefings? What I'm trying to avoid is late filings where attorneys and parties are unprepared for the hearing.
Craig Rappel on behalf of Mr. Your Honor, I think most of our arguments originally were outlined either within the motion to dismiss in this case, as well as with what we filed for declaratory relief and the motion before the court.
All right. Anyone planning on filing any paperwork for the hearing to be held on Friday? I do like to be prepared for my hearings, and I do study up on the issues before hearings.
Your Honor, I don't know that we would be defendants in that case. I don't know that we have anything. If we were to come up with something or think we needed to advise the court of anything, would Wednesday by the end of day be too late for that? I don't have anything specifically, so I'm fine, but I understand you don't want to get something on Thursday or Friday.
That's correct. I believe Wednesday is timely and sufficient. So if anyone is filing anything for the currently scheduled hearing on Friday, please have any paperwork filed by Wednesday at 5 o'clock.
Thank you, Your Honor.
You're welcome, and that gives me time to prepare for you.
Thank you, Judge.
You're welcome. Is there anything else we can cover?
I don't believe so, ma'am. Craig speaking.
Nothing else from Mr. Motti?
Nothing else?
Nothing, Your Honor.
All right, thank you very much, everyone. And unless it's resolved between now and Friday, which I, again, strongly encourage, I'll see y'all on Friday.
Great.
Thank you.
Thank you, Your Honor.
Thank you. Have a great day.
So, bye.
Bye-bye.